So before we go into the actual trajectory that the case takes, I just want to talk about what are the different kinds of cases that can be there. Broadly, the divisions are just civil and criminal, which is why the two main procedural codes that govern these cases are the Civil Procedure Code or the Criminal Procedure Code. Now, under them, you can have different nomenclature of cases depending on what kind of legal domain they're targeting. So you can have something like a constitutional writ petition, which can be either civil or criminal, depending on what they're arguing. Similarly, you will have some statute specific cases like a land acquisition case, which is essentially a civil case. But again, it is a more nuanced classification for the case. So broadly, the classification remains twofold, that is civil and criminal. And under that, depending on the legal area or the specific legal domain that you're targeting, you can further classify the cases. And that is how the case codes are created in different courts. Coming to the trajectory of a case, let's talk about a civil case. So at the trial level, if it's depending on the pecuniary jurisdiction is essentially the amount of money that is involved. So if it's a land dispute, you will typically talk about what the valuation of the property is on the market. And depending on that valuation, you will file your case before the appropriate judge. So if it's a low value, then you will typically go to the civil judge junior division, or sometimes they're called civil judge first division or second division, depending on, again, like that can vary from different district courts. And if it's slightly more, then you will typically go to the civil judge senior division, and he will be your starting point. Now, in the trial, the first thing that a party needs to do is file a plaint under the CPC. The plaint is essentially the substance of your case, where you put together a written document for the court's consideration, setting out the main causes of why you are coming to court, along with the documentary evidence that you want to prove or utilize to sort of prove your case. After you file the plaint, the court will prima facie, like look at it on the face of it, see that there's no defect or anything, and then proceed to issue notice to the other side. Once the other side appears, now they will also file something called the written statement, which is essentially the sum and substance of their defense and why they feel that your suit is not a valid suit. Once these documents have been put together and both sides have produced their supporting documentary evidence, there is a stage where each side is allowed to sort of admit or deny the evidence that has been produced by the other side. The idea of this is that right from the get-go, as a party, I have access to the other side and what the other side will be relying on, and therefore there's a fairness to the system and nothing is basically sprung up on me in surprise. Once the admission denial stage concludes, then after all this, the trial court will formulate the questions of law and fact that it has to adjudicate on. Now, these questions are important because they are essentially the court's comprehension of what is relevant in the dispute and what it needs to sit on in judgment and be the arbiter of. After the framing of questions, you essentially start the whole trial process, where there is a filing of evidence from the plaintiff, and there can be, if the defense feels, they can cross-examine the people who filed their affidavits in evidence. Once this whole trial process and the recordal of evidence is done, then parties are allowed some time to sort of close their oral statements and bring home the arguments to a closure, after which the courts will essentially sit in judgment, give the judgment. Now, after that, it can either go to the execution of this judgment, which is called the execution of decree, or the party that has sort of been dissatisfied, or it can be both parties if they're dissatisfied, they can take their appeals to the next stage. Now, in this case, if it's going before a civil judge, be it junior division or senior division, the first appeal will basically go to the district judge. And if it's directly in the district judge's court, then it will go to the high court. And in the high court, again, now there are certain rules in every specific high court depending on who is going to listen to the first appeal or to the second appeal, etc. And there are certain letters patent rules in some letter patent courts like Delhi and Bombay, where the letters patent will govern who is listening to and how is he or she listening to these appeals. From these appeals, once the High Court has, again, one important point here is that you can rarely appeal a question of fact. Mostly your appeals will have to be on the interpretation of the law. The facts can only be challenged if there is some grave injustice or some very obvious disregard to the factual situation. So any appeal will never really talk about your evidence per se, because that is a question that has been determined in finality at trial. And this is true even when you file appeals before the Supreme Court. So from the High Court, whenever the judgment has been delivered, now either again parties can be content with what they've got, or they will go to the Supreme Court and appeal, which is provided under the articles of the Constitution, under Article 133 or 134, depending on whether it's a civil appeal or a criminal appeal, with the permission of the High Court. There is an independent process I want to talk about, which is Article 136 of the Constitution, that talks about a special leave petition. Now, this is a special power of the Supreme Court, being the top court, like I had said earlier, of the country, and it can essentially sit in judgment over any kind of proceeding that is happening in any court or tribunal of the country. So, under that power, if at any stage I feel as a party that this order has been gravely prejudicial, that needs the apex court's attention or direct intervention, then I can proceed under Article 136 to the Supreme Court directly, jumping all those initial intermediary stages and go directly to the Supreme Court. But there is to be a caution here that the exercise of this special leave petition power is extraordinary. It is something that the Supreme Court will not typically allow for, and only with good cause will it actually intervene in these cases, especially if it sees that you have basically committed or undertaken a shortcut of the whole process by sort of circumventing your lower appellate courts and come directly to the Supreme Court. That's broadly the trajectory of the case. On the criminal side, the trial and all essentially is governed under the CRPC. One thing that needs to be there is that essentially a case will start with me going and filing an FIR, which is a first information report in a police station. The police station depends on where the crime has occurred, and depending on the territorial jurisdiction, you will go to the appropriate police station, file an FIR. After the FIR is filed, the CRPC provides for a certain amount of time for the police to carry out its investigation, and the police can sometimes get an extension on this time period depending on some circumstances that it can present to the court. But once the investigation is completed, the police will file a charge sheet before the trial court, and then once the charge sheet has been filed, that is essentially your initiation point of the criminal trial. After that, the judicial magistrate or the additional sessions judge will look at the facts and see if all those people on the charge sheet are actually prima facie culpable, or there's a legitimate case to be made, or they can delete certain people off these charge sheets. And from there it progresses. Again, the process will essentially be the same, that the charge sheet has been filed, parties will be notified. Now, unlike a civil case, a prosecution will always be in the name of the state. So typically your cases will always be the state or government of India or Union of India versus so and so, etc. so on, or a state agency like CBI versus Mr. XYZ. And that is broadly, and from there again you go into the whole cycle of appeals, and the appeals are essentially the same, that from the trial court you will progress into the High Court, and from the High Court you can progress into the Supreme Court.
Good.